So good morning, everyone, and welcome to AKAM's educational webinar series on navigating HOA violations, legal update, and smart enforcement strategies. This is so important, smart enforcement strategies. Well, my name is Maureen Reyes. I am the Vice President of Business Development for AKAM, and I am pleased to have with me today in this program, Jen Adams, Senior Vice President of Operations and Management, and Steve and Michael from Sachs Sax Caplan. Before we jump into the intro, just some house rules. There's a chat that if you have any questions, please feel free to put them in there. We will be addressing them during the call, and at the end, we're going to try to leave 10 minutes so we could answer them thoroughly. And also, if you're here for your credit, please email me your LCAM number, and we'll make sure you get your credit. So that's about all. Jen, I want to get started with you so you could introduce yourself.
Good morning, everyone. My name is Jen Moxie Adams, like Maureen just graciously announced. I am also a senior VP with AKAM, where I work closely with our managers and boards on operations and compliance related matters. So I'm excited to be here. Thank you.
Thank you. Steve, Mike.
Okay, I'm Steve Rappaport. I'm a partner at Sachs Sax Caplan. I've been with the firm for 23 years and exclusively practice in HOA and condo related items. So happy to be here. And Mike?
Yeah, Michael Ungerbuehler, also a partner with Sachs Sax Caplan in the Community Association Group. Happy to be here as well. Thank you.
Fantastic. Well, let's dive into the details.
Okay, I'll lead it off, Mike, if you want to get the slides up.
Yeah. Give it seconds. And there we go.
All right, so let's move to the introduction page. And so before we get into the fining process and a lot of the other procedures and stuff, I think it's important to sort of give a sort of 10,000-foot overview of the covenants and what enforcement means in the first place. And I think we need to always start off with two questions. And you'll see in the intro it says, what is a declaration, and so on and so forth. But when it comes to enforcement, I think the two questions you have to ask yourself is, what are we even trying to enforce in the first place? You know, remember, we're trying to send a letter to somebody telling them not to do something or do something that they haven't done. So the question is, what are we trying to enforce? Where is it in the documents that says they have to do what we want them to do, or that they haven't done what we want them to do, or we want them to change something that they've done because they've done it the wrong way? Whatever it is that we're trying to seek a remedy on, we need to be able to find something in the documents that says that. You know, if you were a country club, if you were a private, non-merged country club, you could pretty much do anything you want. If somebody calls you a name on the golf course, you can send them a letter and tell them they're suspended for 6 months, and you can get away with that in the country club world. But we're in the HOA or condo world. We have to deal with 720 and 718, and those statutes say that in order to move forward with enforcement, you need to be able to enforce your governing documents. So step number one is always, what are we trying to accomplish? What is it that we're trying to have this person do? And where is it in the documents that say it? So that's the starting point. And I think the other important thing to know is where in the governing document. So we've isolated the language that we're trying to enforce. Where is it that we found that language? That's the second point. So, okay, great. We have something that says pets can't be more than 15 pounds, or we have something that says no commercial vehicles, or we have something that says that you can't install a wooden fence, but you can only install a picket fence, or whatever it is. Okay, great. So we've identified the covenant or the rule or whatever it is that we're trying to enforce. Question number two then is, where did we find that? Is it in the declaration? Is it in the rules and regulations? I think that's also the second most important thing, because you have a hierarchy of documents that you have to deal with. Your declaration always comes first. That is your most important, most superior document. Your declaration of covenants or your declaration of condominium, if you happen to be in a condominium, that's sort of your constitution. It's the document that runs with and binds the use of the property itself. You then kind of go into your articles of incorporation, which is the number two document that rarely deals with covenant enforcement. That's more corporate in nature. Same with your bylaws. The bylaws are your number three document. So that will more go into the size of your board and your election procedures and nominations. And again, rarely do you have covenants or anything that you're enforcing in the bylaws or the articles. So then you come to your rules and regulations, which of course is fourth on the depth chart. And we love rules and regulations, right? Rules and regulations are our best friends. And why is that? Because generally speaking, the board can adopt rules and regulations without having to go to those pesky members for their vote to amend the rules and regulations. So we love throwing everything we can into the rules, as opposed to trying to amend the declaration with a 2/3 or a 3/4 vote, right? Except the problem is when you have a conflict between the two, the declaration is always going to control over the rules and regulations. And those can sometimes be obvious when the declaration might say you have a 30-pound pet weight and the rules and regulations might say 45 pounds. So there you have a conflict, but it's not always as obvious as that. And I'll give you an example. I had a client once that called me up and asked me to send a demand letter to somebody because their tenant did not get approved. And they have an application process and an approval process, and the person didn't submit, and they wanted me to send a violation. So I go through their governing documents. I don't really see anything. So I asked them, well, where is it that where's your approval process? Oh, here's our rules. It's been in our rules for 20 years. I said, okay, that's great. You've got good rules. So I went back to the declaration. They had general rulemaking authority. They didn't have rulemaking authority over leases. And there was a very broad language in their easement section that talked about the rights of owners and their tenants, guests, and invitees to have access to the properties at all times. So I had to go back to the client and say, it's great that you've adopted these rules and you've been enforcing your rules for 20 years, but your declaration doesn't have any restrictions on rentals. It doesn't say rentals are subject to additional rules and regulations adopted by the board. And you've got a very broad easement right here in your declaration, which again is superior to your rules and regulations that says that the property is for the use of owners and their guests and tenants and invitees. And just by the use of that word tenant, granting those broad easement rights to me was giving tenants basically an unfettered right to be there, regardless of what you have in your rules and regulations. So again, before Michael jumps in and starts talking about all the different finding and suspension processes, the 10,000-foot approach is step number one. What are we even seeking to enforce? What is the language that we're looking to do? What are we trying to enforce? And then secondly, where is it? Is it in the rules? Is it in the declaration? If it's in the declaration, it's great. That's great. It's clothed with a presumption of validity based on the case law. If it's in the rules, that might be okay. But again, we have to go a little bit further and say, all right, is there anything in the declaration that conflicts with that rule? If not, does the declaration provide rulemaking authority? Does the declaration provide additional rulemaking authority explicit to that particular issue? If you have all of those things, we have a covenant that we're clearly attempting to enforce. And we know it's in the declaration, or we know it's a rule that we clearly have the authority. Okay, great. Now we have the ability to enforce the documents. And now what are our options? And so I think if we move to the next slide, it starts with the finding process. Michael, if you want to start it off and I'll chime in, but the next step is what are the options that we have once we've identified that we have a proper and enforceable covenant?
All right, so I'm going to jump into the find process. Okay, so what we're going to talk about now is the chapter 720, specifically 720.305, statutory process for fines and suspensions. All HOAs must follow this statutory process in order to levy fines and suspensions. So it's a 4-step process. Before you get to the 4 steps, the first thing you have to have is a fining committee. The statutes require that you first have a fining committee. That fining committee must be at least 3 members of the association that are not the officers, directors, employees, or manager of the association, or any of those people's family members. Must be at least 3 of the members of the association. Once you have that fining committee process in place, then you can move forward to the process. So the first step, number 1, the first step is to levy the fine or suspension. So typically, the board is the entity that levies the fine or suspension, and that's done at an open board meeting. There are some caveats to that, but if the board has adopted a resolution delegating the ability to fine or suspend to management, then management will be able to have the right to levy fines or suspensions. Boards do have the authorization, the ability to delegate this to management if they want to. Make it a little bit more of an automated system, set it, forget it, let management handle that. But if it's the board that's doing it, it's done at an open board meeting. Like I said, there are a couple of caveats to that. If it involves a violation of an employee or personnel, then the board could actually have a closed meeting without counsel there for personnel matters. And at that meeting, if there's a quorum, then the board could adopt and approve a fine or suspension at that closed personnel meeting. Also, if it's something that's a little bit of a sensitive nature or a particular issue, or an owner is already threatening to sue the association about the matter, and the board wants to discuss the matter frankly, then they would have counsel present. And during a closed legal meeting, the board could, at that closed legal meeting, adopt the fine or suspension. And then finally, in lieu of a board meeting, you could also have a unanimous written consent where the board adopts the fine or suspension that way. But the typical process is it's done at an open board meeting.
Yeah.
So that's step number one, levying of the fine or suspension.
Okay. And let me just chime in real quick on a couple things you mentioned. On the delegation authority, we do those resolutions all the time, and that works really well for large communities, especially when you have hundreds of violations and you don't want to have to go to the board every single time. But always be aware that, the statute says, uses the words levied by the board. So it talks about the fine or suspension levied by the board. The safest approach is always to have your fine or your suspension levied by the board at a duly called and open board meeting. But if you're one of these 2,000 home communities where you get 200-300 violations a week or a month, you've got a roving violations coordinator separate from the property manager whose sole job is basically deed enforcement and goes around the community to identify violations, and you want to be able to just send those letters directly from management to the owners to clean up their lawn or whatever it is, then the board at a duly called and open board meeting should adopt that resolution to delegate that authority to management or to management's representatives to identify violations, to send violation letters to owners, to propose fines based upon an approved fining schedule that was adopted by the board, and to start that 14-day notice and hearing process, which we'll get into in a little bit. So again, the delegation still needs to be done at an open board meeting, and we've always taken the position that the board inherently has a right to delegate its authority. So that's the way a lot of these larger communities operate, to allow management to kind of take the process and run with it without having to come back to the board every single time they want to impose an individual fine. But again, the safer approach and the more conservative approach is always have the board at an open meeting approve each individual fine. The other thing I do want to point out before we move to the next slide is you mentioned the need to have the 3-person committee. I get this question all the time. Steve, we don't have this committee. How can we can't send out violation letters? We can't enforce our documents. That's not the case. The committee is only needed for levying of fines and suspensions, and that's one of your alternate remedies, which again we'll get into in some later slides. You always have the right to enforce your documents. If you as a board or management want to send a violation letter, want to send the person to the attorney to send a violation letter, want to take them to mediation or court to enforce the documents, you don't need a committee for those things. You have the right to enforce your documents. It's only if you are trying to levy a fine or a suspension that you need that independent 3-person committee with the hearing on 14 days notice and so forth, which we'll get into. I just wanted to clarify that before we move on to the next slide.
And Steve and
Yeah.
Mike, in the part of operations, one of the things that we find value, it's again working with your legal counsel. That's the first step, because you have to have a very clear SOP, because
Right.
that's the only way that management can enforce and do the things right. Because you don't want to go ahead and start sending violations without, again, making sure the rules were correctly passed, making sure everything is correctly done. So I think one of the things that we always, recommend to the boards and maybe new board members that might not, have that understanding is, wait a minute, pause, let's make sure everything, is basically given the green light by the attorney association, legal counsel. I think that's working closely with your expert is a must, because you can't just, even if the board is an attorney or whatnot, like you want to make sure you're safe to enforce.
Yeah, and look, that's 100% right. And look, we all know that, billable hours, and we get it, boards don't want to spend what they don't have to spend. But I will tell you 100 times over, it is cheaper to keep you out of trouble than to get you out of trouble. So
Yeah.
yes, always consult with your counsel. If you have a good one, they will, keep things as cost effective as possible, I'm sure. But yes, on major issues like this, especially enforcing your documents, you want to consult with your association's attorney. And we hear this all the time with boards who have their in-house internal counsel, because they have somebody on their board that's been practicing law and that's great, and that person is very valuable to us, and that person's another extra set of eyes. But that person may or may not be a Florida licensed attorney. That person may or may not have specialization in HOA or condo law, and that person is probably not going to be covered by the malpractice insurance if they give the board bad advice. Whereas you're getting good advice from your paid attorneys through our firm or through whatever firm you're working with. So yes, 100% always consult with your attorney on these types of issues.
Perfect.
Perfect. Okay, so that was step number one, levying the fine or suspension. So the second step, the notice to the owner. Florida's brand is basically notice and opportunity. They always want everyone to have notice of all the laws and everything that's out there. So you have the opportunity to comply or face the consequences. So the state's always going to be thinking notice and opportunity. So after the fine or suspension is levied, step number 2 is the initial notice to the owner that says, hey, and you lay out a number of levels of information to the owner. Tell the owner you've done something wrong or you haven't done something you were required to do. So you've committed a violation. Well, what is that violation? Explain what the violation is. Then cite the provision of the governing documents and rules and regulations that was violated. Then you need to tell them what is it that you can do to cure the violation if the violation is curable. So for instance, if you're a larger community and you have rules on speeding in the community, somebody speeds, well, you can't unspeed the car. It's not Ferris Bueller. You can't back the car up forever. Speeding happened, you can't cure that. So that wouldn't be something that was curable. But if somebody paints their house polka dots without getting approval, or if the association doesn't allow polka dot painting, then that's a curable violation. You unpaint that, you paint it back to the way it originally was. So that is what you have to do. If it's a curable violation, you explain it. Now, importantly, and we'll talk about this a little bit further later, but anytime it's a curable violation and you're telling the owner how to cure it, you must make certain you impose a deadline to cure it. And again, we'll talk about why that's important in a moment, but anytime it's a curable violation, always state you have X number of days to cure this violation. That's part of the process to be able to cure it. So once you've gone through those things, you also obviously need to tell the owner or the tenant or whoever you're sending the violation notice to with the fine and suspension, we're going to have a fine and committee hearing. It's going to be held at least 14 days up to 90 days after the date of this letter. It's going to be located at this place, at this date, at this time. You can do it by Zoom. You can have a hybrid style. You can do it all by phone call. And the statutes were amended in 2024 to make it clear that owners have the right to attend these meetings by phone or by Zoom or Teams or whatever. So anybody can be anywhere on the face of the earth and attend these meetings, the owner and the finding committee. So it's just important to keep that in mind, and you put all of that information into there. So that's the notice. Steve, it looked like you had a comment.
Yeah, I saw a couple of questions in the Q&A that I wanted to tackle, and one of them we're going to deal with a little bit later on. But before I comment on what you just said, so there's just a quick question: does Florida law supersede all the documents? That's kind of one of those I can answer with a definite maybe kind of answers. Yes and no. I mean, Florida law in a conflict, Florida law supersedes what's in your documents, but it's going to depend a little bit on what's in that second question about whether Kaufman language exists, and we do get into that a little bit later in the presentation. So I'm going to punt that issue a little bit to later to deal with Kaufman. But again, if there's a direct conflict between statute and documents, statute will generally control. That might be a little bit gray area depending on Kaufman language. But the documents can sometimes be more restrictive than statute. So for example, if the statute sets a minimum level of something or a minimum notice requirement, but your documents require additional notice, your documents can be more restrictive than the statute. Sometimes the statute will say, unless otherwise provided in the governing documents, A, B, and C shall apply. Well, that means that if the documents can put something different than what's in the statute. So, there's no straight answer to that question other than it really depends on the issue and depends on what the documents are saying, whether there's an exact conflict and so forth. But again, general answer is statute always supersedes in the event of a conflict. How to handle differences in interpretation. We'll get into that, I think, a little bit later. But again, I think the issue is if you've got a covenant where it's not 100% clear what it means, then my recommendation is always you need to amend that document then. You need to amend it to make it clear so there is no ambiguity or vagueness that you have to deal with. So if there's differences in interpretation, hopefully you can get an opinion from your legal counsel as to what the proper interpretation is, and then you can rely upon that opinion from your attorney. But that attorney might turn around and say, you know what, it's a little bit of a gray area. That's an ambiguous thing. If it's a rule, maybe you need to, as a board, to adopt a new rule or to clarify that rule. If it's a declaration provision, let's see if we can get 2/3 of the owners or majority, whatever the declaration requires to amend, to do an amendment to clarify that language so that moving forward we can deal with it better. And then finally, on the delegation, Courtney's got a question. They've got a resolution from 2013 that delegated to the executive board the authority to levy fines outside of a board meeting. I think the same approach, that's the same thing as delegating to management. So if you have a proper resolution that was adopted at a duly called open board meeting to delegate to some executive board or executive committee the right to levy fines, then that to me is the same as delegating it to management. And I think that should be fine. So. And then on Michael's comments about the process, 100% agree with everything. My biggest comment is the whole how to cure and the debacle that's given to us with the new legislation, because, that's great. Yes, Michael's example of, leaving trash out on the curb or whatever, and we'll get into that later based on the new laws, but leaving trash out where it's a one-off thing, that might not be curable if the time's already passed and they've already, it's already happened. Cleaning the roof, that's an easy one. That's curable. You have to clean the roof to cure the violation. But let's say you've put a sign out on your front lawn that's a violation of your documents, and you get a letter that says you've got 7 days to remove the sign, and you don't do it. And then they send you the fining notice saying, okay, we've got a hearing in 14 days to fine you $100 for putting this sign out on your property. And on day 13, the day before the hearing, the person removes the sign. Okay, great. They've cured the violation before the hearing, so we can't fine for it, so we cancel the hearing. Guess what happens on day 16, 2 days after the hearing was supposed to happen? They put the sign back. Did they really cure the violation? Do we have to start the process all over again with a new notice? I mean, I personally would argue that they didn't truly cure the violation, that wasn't a curable violation. If you can take the sign off and put it back on, or take the car out of the driveway and put it back in, or whatever it is, I would argue those aren't curable violations, but the statute's not very clear on that. And hopefully that's something that over the next year or so, they'll help to clarify, but just wanted to comment on those
Yeah.
issues.
Stephen and Michael, I also received a question related to curable fines or hitting the deadline on the curable fine. So if they partially cure the fine before the deadline, is that clock reset, or do we go on with the violation? So maybe using the roof as an example, it's partially clean. So what
Yeah.
do we do? Do we reset, or?
Yeah. Well, not to sound like Bill Clinton, but I think it depends on what your definition of partially cured is. I mean, what's the definition of is? If if the violation is, I've levied $100 a day fine for the fact that you didn't clean your roof, and you get up there and you send a cleaner out there, and they clean half the roof, or they clean it, but it's not really done well, then I would say that's not cured, and you can move forward with the process. So what does it mean by partially cured? Do we have 3 violations where they cured 2 of the 3 violations and 1 remains uncured? Well, then you probably should have levied 3 independent fines with notice of the 3 fines. And if that's the case, then I would say you can't collect on the 2 fines for the violations that were cured, but on the 3rd violation that wasn't cured, you can certainly move forward with the hearing and the notice and so forth for that, and move forward with that fine. So depends on what exactly the facts are and what they actually did. But statute says if it's cured, you can't collect the fine. So I would say if there's any argument as to whether or not it was cured at all, then I would still move forward with the process, because they need to completely cure it in order to avoid the payment of the fines. Other thing I'll point out before your next question is, remember, and I think this is mostly HOAs here, but there might be a few condo people on the line. This particular issue of the curable is really an HOA issue. This was put into 720 last year. So if you're 718, I still think it's good practice to put in your letters how to cure and so on and so forth, but that's not an issue for 718 condos. It's a 720 issue only.
Okay.
Yeah.
We had one question pop up on the Q&A. Can the violation notices be emailed? Yes, the statute says the notice that's sent out to the owner or the violator can be sent. It has to be sent to their designated mailing address or their designated email address in the official records. Obviously, if you're sending an email notice, which is an official notice, you need to have the written consent from the owner saying, I accept or I consent to electronic notices. So you'd want to make sure you have that if you're sending this notice by email. You don't want to risk messing that up in any way, because then that unravels the whole violation fine process.
Okay.
Steve, there was
That's
a
a great
follow-up
question.
question from what, Maureen?
That's a great question,
Yeah.
because that's where it becomes tedious. It's if it needs to be certified or not. And again, you have to follow what's the rules that you have already, or the SOPs that you have. That's a good question.
Yeah.
Yeah, and then for the follow-up question, I think the bottom line is the delegation of authority needs to be done at a duly called and open board meeting. Whether you have a formal resolution signed, that's the preference. We've drafted those, so we would certainly prefer that you have a formal resolution. But if it was adopted by the board, the delegation is approved by a majority of the board at an open meeting, and it's referenced in your minutes, and it's memorialized that it happened, then I think you're probably okay with that. And if that didn't answer the question, I know Courtney knows how to find me, so we can talk offline on that issue.
All right. We just got a question pop up in chat. Does the rule about violations cured before the hearing apply if you don't have Kaufman language? No, it doesn't. And we'll get into that a little bit deeper when we get more into that part of it.
Okay.
All right, so that was step number 2. So again, number 1, levy the fine or suspension. Number 2, notice to the owner saying you've been a bad boy or girl. Here's what's coming. All right, so then number 3, the committee hearing. So now we have the committee hearing. And again, the hearing has to happen 14 to 90 days after that first notice is sent out to the violator saying that it's going to happen. Like I said earlier, the committee hearing is done in person, by telephone, by Zoom, by whatever, any other electronic means. So that's nice. They've made it clear in the statutes that it can be handled in any technological process that we have. Now, importantly, the committee's sole function is to be, back in the day of the gladiator times, to thumbs up or down the fine or suspension. That's it. That's all they get to do. They can only say confirm or reject, or say yes or no to a levied fine or suspension. They don't get to play King Solomon and split the baby. They don't get to say, well, this is too much of a fine, but we'll agree to a lower fine. They don't get to do that. They don't get to make any modifications at all. If they think it was an excessive amount of a fine, or they think the owner maybe learned their lesson and they don't want to impose it, then they can reject that, and they have the statutory ability to do that. But they can only say yes or no. If the committee does not confirm the fine or suspension, then it may not be imposed. If they do confirm it, obviously, then we move on to step 3. And then something we've already kind of talked about, if the owner, and Steve went into length about that, if the owner cures the violation before this committee hearing, then the fine or suspension may not be imposed. And again, you can see right there, it only applies if you have Kaufman language in your documents. And we'll talk about that more, but very briefly, that's if your governing documents have some phrase, Florida statutes, or specifically 720 as amended from time to time, something to that effect. And one of the things, look, the fines aren't meant to be a moneymaker for the associations. Fines and suspensions are meant to modify behavior. So when this first came out, everybody's like, really? But then if you think about it, we want people to do the right thing. So the fines or suspensions are there to modify behavior. And look, if someone has committed a violation and it's curable and they fix it before the hearing, maybe they learned the lesson and they're not one of those ones that'll try to do it again, that's not a terrible thing. So it kind of makes sense that, look, if we've gotten them to modify the behavior to remove the curable violation before the hearing, then it kind of is like, okay, well, why are we still doing the hearing? So, there may be some kind of violations where, like, well, this person's kind of a jerk, or they constantly do this thing, and, maybe there's some other way to approach it. And there are, we'll talk about that later. But I think personally that might be one of the reasons why the state kind of thought that, look, you're trying to modify behavior, and if the behavior has been modified before the hearing, then there's no reason to press forward with that.
Okay.
You have any comments you wanted to add, Stu?
Real quick, there's a question that just came up that's a really great question. Can the delegated, we were just talking about the delegation of authority in the last slide, can the delegated body be the members of the fining committee? To me, that is an absolute no, because remember, the statute says that the fining committee cannot be the members of the board, officers, directors, or their family members, and so forth. So the point of the fining committee is to have that independent body of 3 individual owners who are not related or not on the board. So to me, if the board has delegated its authority to some other body or to management or whoever it is, some executive committee, those are people that are operating with the authority of the board, so they should be treated as the same as the board, and therefore that the fining committee should not be those same people. You shouldn't have the committee say that there's a violation and send it to basically itself to then be the judge and jury over whether or not to impose the fine. So no, you want to make sure whether it's the board or whether it's a body of the board being delegated, that they are entirely independent from the fining committee that's ultimately going to vote up or down the fine.
Yeah.
And one
And I
question,
think I think one of the keys that you mentioned there, Mike, is that, it's not a money maker. It's making sure that everyone behaves. So, we've taken in, beautiful communities where speeding was a problem, right? And speeding is safety. So again, you work with the attorney and the board to make sure it makes sense to enforce it, because it's not about making the money. It's about, making sure no one gets, ran over because of speeding. So that's critical and it's important, that we always keep that in mind. I had a community that we managed years ago, and I had 2 covenants, by 2 violations coordinated. That's the amount of violations, and they weren't behaving until they behaved. Took a while, but that's the goal, is, everyone, and that's why you buy into an HOA too.
Yeah.
right? Yeah, and one question popped up. We basically got a weekend violator. Boats aren't allowed in the community, and this person just brings the boats in on the weekend, but then moves it for the week. So can they be fined? Yes. That would be one where we think it would be really good to work with the attorney come up with proper language to address this particular violation. It's not a constant, continuous violation, but it's a repeated one. So you'd want to craft that properly and say, look, you're violating, it doesn't matter, you're removing it during the week. You're still constantly and periodically violating the declaration.
Yeah, and by the way, and we're going to get into the other enforcement remedies that we have in a couple of slides, I think. But remember, fining is an alternate remedy. It's one of your many remedies. Sometimes fining isn't the best remedy. Sometimes fining is kind of meaningless. So don't. It's not the end all be all. If it's a type of violation where someone's moving a boat in every other weekend, that's a violating boat. Maybe a fine isn't the way to approach that. Maybe trying to get into mediation and trying to get a court order, force them to never bring that boat back onto the property again. Maybe that's the better approach. Cleaning a roof that's going to cost several thousands of dollars to clean, maybe $100 fine up to $1,000 maximum if your documents don't allow you to go above that. Maybe that's not the right remedy because, of course, the person would rather pay the $1,000 fine than spend $5,000 on their roof. So again, fines are good for some things, but they're not the end all be all. So we have to be aware of all of our other remedies too, which we'll shortly get into.
Yeah.
Hey, that's a good point. And I think a lot of our associations they don't realize that that's an option because some homeowners are quick to pay it and they'll continue to do the violation. And they need to know that these other options are available to them as well.
Exactly. It's not like they're buying a variance or something. I mean, that's great.
Right.
So you levied a fine, they paid the fine, and basically they're going to thumb their nose at you and say, well, what are you going to do next? Well, guess what? There's about 10 other things we can do next, but this is one of them. But okay, you paid the fine. Thank you for the money. We'll happily spend it, but there's still a violation, and we're still going to pursue you for the underlying violation. Yeah.
So one
Yeah, and I
question.
think boards need to know that. That's good.
Yes. One good question just popped up. Well, this committee, the fining committee and the committee hearing and everything. So what happens if one of the committee members knows the violator or has a relationship with them? Should they be recused? How do we approach that? We're a little concerned. Well, if, a lot of times it's tough with some communities to even get three members to say, yes, we want to be able to fine and suspend our neighbors and, take that heat on, that the board can't do. So if you have more than three, it's good to be able to have alternates because then you have that ability. You can say, all right, well, we've got a fining committee that's three, but then we've got like two alternates in case one of the three knows the violator. Then you've got that scenario where, okay, this person knows them and they need to disclose that to the association. Say, hey, I actually know the violator, so I need to recuse myself from this particular matter. And then alternate one steps in. So if you have that, I think that'd be good. But if you only have three and the one person knows the violator, if you want to pursue the fine or suspension, I don't think you really have a choice there. You have to leave them on. And if they don't follow and do the right thing and perform their duty right, remove them from the committee afterwards.
Yeah.
All right. So I'm going to move on. That was the committee hearing. So then again, Florida says notice and opportunity. So after the hearing, now there's another notice that gets sent out to the violator. And this is the follow-up letter. The state made it clear in 2024, this follow-up notice has to go out no later than 7 calendar days after the committee hearing, which I think kind of makes sense. Keep it kind of fresh in everyone's mind. You don't wait a month later and then say, hey, here's what the committee decided. So after the hearing, within 7 calendar days, another notice has to be sent to the violator. And again, it says, all right, so number one, here's what the committee found. So basically the committee said, yeah, there was a violation, or no, there wasn't a violation. And yes, we upheld the fine and or suspension, or no, we didn't. That's basically what would get laid out. And then again, you have to list how do you cure the violation if it's curable. And very importantly, you set that time frame to cure. Because if you don't, and it's on the follow-up notice, that's a nightmare. So imagine if somebody painted their house polka dots and they didn't paint it back. You had the hearing. They still haven't painted it back. You send a follow-up notice and said, you violated by painting your house polka dots. You must repaint it. But you don't put a deadline on there. All right, and then a couple months goes by. This person's like, we don't care, sue us. So it's all right. Now you get the attorney involved and you sue them and you pursue all of your remedies. And 8 months into it, the owner is like, all right, fine, I'm going to paint it back. Well, guess what? Florida says if they've cured, then you don't get to levy the fine or suspension. But also, if you look at this last point, if you've got coffin language in your documents, and if if they cure, then there's a possibility that you don't get to recover your attorney's fees. So they've done a lot of things with 720-305 that if an owner cures, then you might not be able to recover not only your fine or suspension, but possibly your attorney's fees as well. So it's really important to make sure you're always imposing the deadline to cure. If it's curable, here's what you have to do. Here's how long you have to do it. Just make sure you're doing that. And then again, also note, you've got at least 30 days to pay your fine. So the statute talks about that too. You don't get to collect any attorney's fees until after they fail to pay the fine. So when you're going to give them a time frame to pay the fine, you want to make sure, all right, the statute says it has at least 30 days. You'd probably best to keep it at 30 days. If you make it 60 days because you're trying to be nice and you've got attorney's fees accruing during that time frame, state says you don't get to collect any attorney's fees until the time after the owner doesn't pay from that follow-up letter. So, and again, these consequences against the association, the loss of rights, those only apply if you have Kaufman language. And again, we keep mentioning it. We'll go into a little more detail on that, I think. So this is the final process, the fourth step in the fining suspension process.
Okay.
Steve, from here, do you want to jump into, I guess,
Yeah.
maybe talk about the amount of the fine or suspension?
Yeah.
All right. So,
All right. So
go ahead.
So when moving forward with your fines, the letter goes out, you have the ability under the statute to go up to $100 per violation for a one-time violation, or $100 a day up to $1,000 for a continuing violation. Now, couple things. If you're HOA, this is presumed that there's HOA. So condo, it's a strict $100 per violation, $100 a day up to $1,000, period. HOA, it does say unless the documents provide otherwise. So that's one of those areas where the question earlier in the presentation, does the statute control over the documents? Well, if your documents and this is really your declaration or your bylaws, really not your rules, because this is a little bit of a technicality. The rules are not considered part of your quote unquote governing documents based on 720. So we really can't put these into the rules to go above these $100 and $1,000 limits. But if your declaration or your bylaws say you can levy a fine of up to $250, or you can levy for a continuing violation up to $10,000 in the aggregate, 720 allows the documents to be amended to go above that $100 and $1,000 threshold. 718 does not. So if you are a condo, you are stuck with the $100 and $1,000. But the flip side is also true. This is one of those situations where the documents can be more restrictive than the statute. If your documents say that you can levy fines of up to $50 a day, then you're really stuck with that $50 per day. You can't go above that. You can't do the $100 because the documents were, for whatever reason, drafted to be more restrictive than what the statute allows. So I have a client that does have a $50, it's actually a $50 violation and $10 a day up to $1,000 for that particular community. So we're kind of stuck in that world where, yes, they eventually can get up to the $1,000, but it takes them a lot longer to get there because they can only do it in $10 a day increments because of their declaration as opposed to the statute. So be very
How
careful
old
about
was that document? Sorry.
what's it, how old was it?
That seems very one-off, right?
They were from the early 90s, and we tried to amend it to,
Oh,
and
not
the owners wouldn't go for it. We couldn't get the 2/3 vote of the owners
Interesting.
to go above that. But either way, it's if the documents are more restrictive, then we go with what the documents say. But it's $100 in general for a violation, $100 a day, up to $1,000. A fine of less than $1,000 cannot become a lien. This is really important for HOAs. Again, condo, very different. You can never lien for a fine in the condo world. But for an HOA, if you have $1,000 or more fine, then that could become a lien. So you have a little more leverage in the HOA world that if somebody has a continuing violation that hits that $1,000, or if your documents were amended to allow you to go above that, then you would have the right to possibly file a claim of lien for the collection of that and potentially threaten foreclosure. So that's very important to know. And then suspension of use rights. We talked about the whole process, but in addition to levying of fines, you can also suspend use rights for a reasonable period of time for those same violations. So somebody violates the documents and the board wants to propose a $100 fine and a $30 suspension of the clubhouse use rights, then you have the right to do that. It goes through the same 14-day notice and the same hearing, and the committee would either vote it up or vote it down. But suspensions of rights for violations would go through the same process as you would have for fines. And then the last thing on the slide is the statute says you can impair but not deny access to or from a home. So what does this mean? the question we get all the time is, can we deactivate their transponder at the entry gate so that they have to go through the visitors side instead of having the automatic access into the community? So years and years ago, the statute said that you could not impair an owner's right of ingress and egress through the common areas. And the word impair was a very, very broad term. And clients would ask us, well, can we deactivate their transponder? And we would say, well, it's kind of iffy because the statute says you can't impair their rights of ingress and egress. But we would argue, you know what, we're not impairing your rights. We're making it a little inconvenient for you. You still get to come in through the gate. You still get to access your home. You just have to stop and say hi to the guard and make sure to show your license and make sure that they let you in. So it's a minor inconvenience, but we're definitely not impairing you. So it's totally okay for us to do that. Well, the good news is about 3 or 4 years ago, they changed the statute and they removed the word impair, and now it says we cannot prohibit an owner from ingress and egress to their home. So now I think the answer is even easier. When somebody says, okay, well, can we cut off their transponder and force them to use the visitor gate? Then I think the answer is very simply, absolutely, we can do that. The statute says we can't prohibit their ingress and egress. So we're not prohibiting their ingress and egress. We're just impairing it a little bit. So no big deal. We're allowed to impair them now. So I think the easy answer is yes, you can suspend their use of the amenities. You can suspend the clubhouse use. You can suspend their right, their transponder or their fobs to get in and get out for a reasonable period of time. But again, you have to go through that same 14-day notice and hearing that you would for the fine. Has to be proposed by the board on the front end or through a delegation to management on the front end, and then go through the same process that we talked about for fines.
Steve,
Yeah.
what about voting rights?
Yeah.
We're going to get into that.
Yeah, we'll get into that in a little bit, but the short answer is you can't suspend voting rights for violations,
Right.
but you can suspend voting rights for delinquencies. And there's a difference between suspensions for violations versus delinquencies, and we'll talk about that, I think, in the next slide or two.
Yeah,
Perfect.
just before we
Sorry.
do, no, it's okay. We just got a
It-
bunch of questions on the amount of fines while Steve was talking.
Okay.
Yeah.
The first one, did you say the max fine is now higher than the $1,000 cap, or was 10,000 just facetious?
Partly facetious, but no, it's the statute still says it's $1,000 under 720, but it says unless the governing documents provide otherwise. So the statute hasn't increased the cap, but it's allowed you as an association to get a vote of your members to amend the documents to go to higher than that $1,000. And I've had some that have done it with no cap. So I've actually had some HOA clients that have amended their documents to say $250 per violation and $250 a day with no maximum aggregate. So that could be hundreds of thousands of dollars in theory. Again, that's a little facetious, but in theory, if you've amended the document. So again, you need to make sure your documents have been amended to allow for that. If they have not, then we're still stuck at that $100 per day up to 1,000.
There's a related question. What if the declaration just says the association may levy reasonable fines without a specific dollar amount?
Well, then if it doesn't give a dollar amount either way, then I think it defers back to what the highest amount allowable by the statute, which would be the $100 and the $1,000 caps.
Yes, I think the declaration we need to clearly state it can exceed the statutory amount or some type of language.
Yeah, and I'll give you one better than that, which I see all the time because the statute used to not allow you to go above the 100 and 1,000. There are some HOA documents that say you can levy fines up to the highest amount allowable by law without giving a dollar amount. So what does that mean? Well, I'm not sure what that means because the law allows you to go above the $100 and $1,000, but only if it's actually expressly in your documents. So if you have a declaration that says fines in the highest amount allowable by law, then I would still argue you're still stuck at that 100 and 1,000 level unless you've amended that section to actually increase it expressly above those dollar amounts.
Right. Now, one more question on dollar amounts. Fines are imposed per violation. So what if you've got the same owner that's got 3 different violations? Does that mean we're hitting them and they're continuous? So that's $300 per day, $100 per violation.
If they're 3 independent violations, truly independent violations, and they are continuing in nature, and the board has levied a $100 fine up to the $1,000 for each of those 3 individual violations, then yes, you can do a $100 a day fine for up to $1,000 for each of those 3. So you could end up with $3,000 in fines if it hits that $1,000 for each one of them. Now, when it comes to the liening process, to me, the lien for where you want to lien for 1,000 or more, I think needs to be that continuing violation. So if you have a violation that's $100 a day up to 1,000 and you hit that 1,000, or if your documents allow you to go above, then I think you can threaten to lien for that. Let's say the person has 10 independent violations that are not continuing, okay, which is hard to imagine having that many, but let's say there's just 10 individual things that person did that are one-off violations that aren't continuing, where we can't do $100 a day. It was just a $100 violation, but there are 10 of them, so there's $1,000 in fines that are owed, $100 for each one. I don't believe in that. It's kind of a gray area, but my personal opinion would be I don't think you can add those 10 violations up to get to $1,000 to then be able to lien for those individual violations. To me, I think the intent of the lienability is for the continuing violation where it's become so severe that it's hit that continuing violation of up to $1,000. So I would just be safe if you've got multiple violations where you're trying to add them up to get to that lien level. I wouldn't do that.
We had one more question, and I'll avoid the specific reference to a specific association, so it's not attorney-client privilege. And we
Oh, yeah,
don't send a bill to somebody. If the community has a POA that controls access to the HOA's sub-community, can the HOA use access restriction as part of the fine situation? I'd say as long as the POA works with the HOA, then yes.
That's interesting. Yeah, I would agree with that. Although there's some, there could be some technicalities, such as if the violation is truly of the HOA documents, but the POA is in control of the gates, can the POA suspend for violations of, somebody else's documents? I think if they're working together, there's probably ways that they can work together to do that. They can probably do some delegation of authority. There might be something in the master documents that allows the master association to enforce sub-association documents. We've seen that in a lot of master association, sub-association issues. I'm probably going way beyond what the scope of this seminar, but I think the simple answer to that is consult with your association's counsel, because there could be ways to do it, but there are very, very big technicalities there when you've got multiple associations dealing with violations and one controls the gate, but the violation is really of somebody else's documents. That can be a potential issue.
Right. All right. I think we'll move into the suspensions that are not related to conduct. This is delinquency.
Right. So we kind of briefly talked about this. So non-monetary violations. I didn't pay my assessments. So if an owner is delinquent for more than 90 days, then the association has the right to suspend both use rights, the same use rights that we talked about as far as transponder rights, the right to the clubhouse, the right to the pool, all that sort of stuff, and your voting rights. They have the right to suspend voting rights for non-payment of assessments when you're delinquent more than 90 days. Big difference here is this is not a committee issue. So think of it as almost like two different spheres. Your day-to-day violations, your non-monetary violations, that's dealt with through board levies the fine or suspension. It goes to the committee on 14 days notice. Committee has to have a hearing. Committee votes up or down the fine or suspension. That's for your day-to-day typical violations that are non-monetary in nature. Delinquencies, I didn't pay my assessments. Different animal. That doesn't have to go to the committee. So that's just a matter of if you've hit 90 days, the board at a duly called board meeting can suspend your use rights or your voting rights. And that suspension lasts, it's not a reasonable period of time like for violations. It lasts as long as that assessments are not paid. So as long as the delinquency exists, you can be suspended, and it's a board decision. But again, very important point. It is not an automatic suspension. I have a ton of our HOAs that come to me and say, hey, we've got 7 owners that are delinquent. We've suspended their voting rights for the upcoming, or they're not allowed to vote for the upcoming election. And I say, okay, great, you've suspended their rights. Oh no, they're 90 days delinquent. They can't vote. It's not an automatic suspension. It doesn't just happen when they hit day 90. Okay, it still requires board action. Does not require the committee action. Doesn't require the 14-day notice and all that. But it still requires an open board meeting and the board to approve that delinquency. And to me, because the statute expressly states that it must be done at a board meeting, I don't think that can be delegated to anybody else. That to me has to be done at a duly called and open board meeting, whereas the other violation, non-monetary, can be delegated through management or an executive board like we talked about earlier. But to me, for delinquencies, somebody hits 90 days, you suspend their rights at a duly called open board meeting, and then you're good to go from that point forward until they pay it off.
Yep. All right, so then the next slide. This
Like
one
I
is
always
all
say, consult with your attorney first
Right,
before
right.
going.
That's right.
Always be safe, be conservative.
That's right. So the next one is prohibited finable offenses. So this took effect in 2024. This slide, as you see right at the beginning, it only applies if your governing documents have Kaufman language. We've been mentioning it throughout this. Like we said, it's just basically if your governing documents have specific language that says any statute as amended from time to time, 720 Florida statutes as amended from time to time. The key is that your documents specifically say any amendments to the statutes are going to apply, some type of language. And again, 90% of the time it's as amended from time to time. So you see that is usually what it is. So there's two types, and just briefly, the two types of changes in Florida law, there's substantive changes and then there's procedural changes. Substantive changes, again, oversimplification. Substantive change is when you're imposing a new penalty or a new consequence for not following a new law, or you're taking away an existing right. Perfect example, 2023, the state of Florida says HOAs can no longer prohibit artificial turf. That is a substantive change of Florida law because it's taken away any HOA's right to prohibit artificial turf in the backyard. And then in last year, they expanded it. Basically, you said you can do anything you want in your backyard as long as it can't be seen outside of the backyard. And again, that's saying regardless of the documents. So that is specifically against or imposed on associations that have Kaufman language in their documents. Procedural stuff, that applies to everybody regardless of what your documents have. We just spent the last half hour talking about a process, the 4-step process and finding and suspension. That applies to every HOA because it's remedial, it's a process. The state likes process, notice and opportunity. So process will always apply to everybody. But when it's a substantive change, when the statute says, regardless of what's in the governing documents, that clues you in. You're like, let me look and see what this says, because maybe this doesn't apply to us. So, and again, this is something you definitely want to get with your counsel to make sure to know whether this applies or doesn't.
Yeah.
So,
Yeah, I think that's great. And again, I mean, this opens up that we could do a whole seminar on just the Kaufman issue and so on and so forth, because it really does take probably 30 minutes to an hour to really get into the nuts and bolts of it. But I think you summed it up great. You know, the question is, and this is why you have to consult with your counsel, is what's procedural versus what's really substantive. So just as an example of what we've talked about over the last 30 or 40 minutes, you know, the finding process itself, the requirement that the finding committee hearing happen within 90 days, the requirement that the notice go out 7 days after the hearing, the requirement that it be a 3-person committee that's not a member of the board. Those process issues are going to apply to you whether or not you have that Kaufman language in your documents or not. But when we get into the issues of you can't levy a fine for the trash violations, or you have to put in the notice of cure into the notice, and if it's cured prior to the violation, you can't levy a fine because they cured it. Those to me are substantive rights. When we talk about our right to enforce our documents, that's a substantive right based upon that declaration, that contract between us as an association and the owners. So when you're taking away our right to enforce our documents, or saying that we can't enforce if they do certain things, that's, I think, is what Michael's saying, is that triggers that substantive issue where we have to think about it and say, okay, this isn't just process. This isn't just the number of days we have to give for something or the type of notice we have to give. This is actually taking away our right to enforce, or you know, a vehicle restriction or a trash restriction, or if they cured it beforehand, we can't impose the fine. That's more substantive in nature. So that's where we're going to look at the documents and see, does it say the statute applies as amended from time to time? If it says so, then we've basically incorporated those new statute changes into our documents and we're stuck with them. So if our documents say 720 shall apply as amended from time to time, then yes, all these new changes are going to apply no matter what. But if our documents don't say that, if the documents are silent, then we're going to still be subject to these procedural changes that happen every single year. But on the substantive issues, that's where we need to consult with counsel, because we might have a way around it. We might not have to worry about it.
Yeah.
Good. See, we're
So-
7 minutes away, Mike. Wow, this has been fun.
yeah, no, there's a lot to it. So
There's
we
a
just,
lot.
I think we're
Yeah.
gonna have to do part 2.
We're gonna have to do a part 2, yeah. You know, with only 7 minutes left, I do want to just get into one thing, because I saw it in some of the questions that you sent us before, and I know it's part of what I usually talk about in enforcement. And again, this is sort of just the 10,000-foot view. We could do a whole seminar on just this, but selective enforcement and what happens if we haven't been enforcing. I really want to get into those issues, because that's probably one of the more
Absolutely.
important things that happens to us. So the biggest defense to any of this is going to be selective enforcement. So you could do all these things perfectly fine. You have the proper finding committee, you've got a provision in your documents, everything is perfect, except for the fact that you've got 7 other people in the community that have done the same thing and you've done nothing about it. That's selective enforcement, and that's a defense that they can raise to you if you do try to take them to court to enforce the document. So, you know, sort of the last piece of the pie, so to speak, on this whole thing is, you know, we got the process right, we've got a proper covenant, we've done everything the right way, we don't have any conflicts between our rules and our declaration, but we've got this potential selective enforcement issue, and that's where we need to, you know, we need to button things up. So whether it's selective enforcement or it's lack of enforcement, because that's the other, it's sort of a two-sided coin. It's either we've got 7 other people that have done the exact same thing, or it's we haven't really been doing anything about these things, but we want to start enforcing now. There is a remedy for you to be able to do this, and I call it cleaning the slate, but there's basically a case law that came out 20 or 30 years ago that basically says that if you basically grandfather the existing violations and you republish the restriction to the community and you put them on notice that moving forward you're going to enforce the documents, that will basically allow you to start the clock all over again, republish the restriction, and be able to enforce on a moving forward basis. So basically, in a nutshell, in 5 minutes summary, if you have that situation where whether it's selective enforcement or lack of enforcement, identify the problems. Get a registry, get a registration of all the violations that are out there. Get a list of what's happened already. Grandfather those violations, have the board meet to approve a republication of the restriction, basically say we're going, this rule, we're going to move forward and we're going to enforce it, and then send a notice to the entire community. I call it a clean the slate letter. It basically says we're cleaning the slate from this moment forward. Here's the rules: no metal roofs, or no white picket fences, or no commercial vehicles, or whatever it is. Here's the rule that we haven't been enforcing. This day forward, we can't have this anymore. We're republishing the restriction. This is notice to the whole community. Now, those 7 people that have the violating vehicle, they'll still be able to keep that vehicle because they've been grandfathered, but it's the violation itself that gets grandfathered, not the person. So that person doesn't get to go and buy a new violating vehicle, or put in a new violating tree, or put up a new violating fence. If they need to replace that car, or they need to replace that fence, or that tree got blown down in a hurricane and they have to apply for a new tree, they don't get to continue violating because you've already republished the restriction properly and put them on notice moving forward. So now you've stopped the bleeding, and now they have to comply with that restriction moving forward. They're just grandfathered for the things that got slipped in before you were able to republish the restriction.
We had a question come up real quick. A prior board didn't enforce a rule. Current board wants to. You're going to need to clean the slate.
Lack of previous board enforcement does not prohibit. It doesn't prohibit a sitting board from enforcing a rule that was previously ignored. But again, you're going to have selective enforcement issues if you just willy-nilly decide to start reinforcing that rule. So you need to go through that clean the slate process and republish the restriction to the community and let everybody know, hey guys, we know we've been a little lax about this over the last few years. And this happens a lot with new communities after turnover. The developer allowed a lot of things to happen because all they wanted to do is sell homes. So the developer let the person put in whatever tree they want or whatever. That's when the new board comes in and says, okay, well, we're going to have to grandfather the existing violations, but moving forward, we're republishing this restriction. This is what the rules are. Everyone's now on notice, and now that new board moving forward can enforce on a moving forward basis.
Yeah,
You,
Steve and Mike and Jenna and I believe all of us will agree. Again, you
Yes.
get your council involved, create those clear SOPs, communicate to the membership. At the end of the day, it's their home, right? So you want to make sure that you communicate correctly, and that way you just don't go blank and start enforcing.
Yeah.
Steve, in 30 seconds or less, all the other remedies that are
Wrap it
not
up.
fine or suspension.
Yeah, so if the finding doesn't work, look, you send your initial demand letter out. That's, you send the friendly letter, you send this follow-up letter. If that doesn't work, you levy fines, suspensions. If that doesn't work, you send them to the attorney. We send a strong demand letter. Ultimately, we might have to go to court. I mean, that's the nuclear option. You may at some point have to go to court. If you're a condo, you may have to go to arbitration, but most of the HOAs, you're going to court to enforce your documents. Be very aware that before you do that, you do have to offer pre-suit mediation. So that's something that you have to go through. You have to send them a mediation demand. They have 20 days to respond and agree to mediate. If they don't respond, or if they fail to mediate, or if the mediation happens and they fail to settle, then you can move forward with your court action and you can enforce the documents. So again, like we said earlier on, the finding is just one of your remedies, and you don't even have to find. If you decide, you know what, this violation is so egregious, we're going to go straight to mediation and a lawsuit, you absolutely have the right to do that if you've decided that it's not a type of violation that a fine is just not going to be effective for, or it's too egregious and serious to even go down that route. You always have that right to send a demand letter, to go to mediation, to go to litigation.
Yep.
Yeah.